Need a search engine optimization SEO services? Then get in touch with our professional and friendly team to learn more about our range of custom and tailored services designed to suit your exact needs. Every one of our professionals have acquired years of experience, which ensures you get the very best. Our experienced staff is waiting to hear from you and to answer any specific questions that you may have on how we can meet your needs. Just ask for a consultation and let us prove our commitment to you as we promise to maintain the highest level of quality and commitment. Your satisfaction is our prime concern. So please, don't hesitate to get in contact with us and let us show you all the great options we have.
And we are the Coalition, loud and proud, outrage porn-free, civilly disobedient media broadcasting live on the Worldwide Coalition Radio Network at coalitionradionetwork.com, facebook.com/the Coalition Radio, on the mighty Twitter at coalition_radio, and of course the mothership, the new one at coalitionradionetwork.com, as well as our Coalition 2.0 and 1.0 versions at coalitionradio.us. Got a very special guest this evening, someone that is now officially qualified under a repeat offender program. He's been with us in our radio days, our digital video days, and now for the first time here at the new coalitionradionetwork.com, Zack Greenberg of the Foundation for Individual Rights in Education joins us live here at the mothership. Zack, welcome back. It's great to talk to you again.
Thanks, Pat. It's great to be back.
Now, you're the program officer of something called the Individual Rights Defense Program. I want to read the mission statement. This is critical because I want to reset, if you will, the relationship here so folks can understand how important FIRE is, not only just to the academic world, for whom they are the preeminent civil rights free speech organization in America, serving out of their Philadelphia office the entire nation, but at the same time represent, I believe, a lifeline to not just students, but to their families. We've documented over the years a number of times where FIRE has gotten involved in a variety of, shall we say, interferences between the student and academic relationship, often pointing out for the very first time how compromised so many universities are in this country with their respect to academic rights and freedom of speech. And so they offer a lifeline not just to the student, but to the student's family, the family support system, and on several documented cases have literally rescued academic careers. It's astonishing to watch these abuses still continue, but even more astonishing is to watch a free market, privately funded organization reaching out, providing interference, legal support, moral support, and philosophical support to a group of people as disparate as the nation's academia is in of itself. This is critical. FIRE's mission is to defend and sustain the individual rights of students and faculty members at America's colleges and universities. These rights include freedom of speech, freedom of association, due process. Remember those words, due process, legal equality, religious liberty, and sanctity of conscience, the essential qualities of liberty. FIRE educates students, faculty, alumni, trustees, and the public about the threats to these rights on our campuses. And most importantly, my words, provides the means to preserve them. Zack, I think you know I'm a fanboy, but congratulations on your continued efforts. What are your responsibilities there? What is the Individual Rights Defense Program?
Thank you, Pat, for that wonderful introduction. The Individual Rights Defense Program, otherwise known as IRDP, engages in direct advocacy on behalf of students, student groups, and professors who've had their rights violated by their universities. This usually entails writing letters to schools, going public with press releases and blogs, and occasionally supporting them with legal services in order to vindicate their rights at these institutions.
How busy are you?
Very busy. We're busier than ever, amazingly. We're on par to break our record of about 1,000 case submissions this year. This is students, student groups, professors, any interested parties reaching out to FIRE, asking for help. And we respond to every single one of them. Even if we can't help, we can refer them to other organizations. We can try to find them an attorney, and we can do all that we can to help them out, to offer them advice and support, and to generally understand their stories and see whether we can get involved.
This is almost a rhetorical question, but at this point, And I know I have family members who work in academia, not only in the teaching profession, but also professionals in administration, a variety of aspects, student life, admissions, the registrars. Haven't school, and by the way, these schools communicate routinely on everything. Some would call it collusion. Others might just call it, well, getting together to understand commonalities. I'll go with the collusion. But anyhow, they talk about, they confer, they compare, they certainly exchange notes. Hasn't anyone figured out that you guys are out there yet?
They have. A lot of schools that we work with want to hear from us. We have a good working relationship with many schools, especially our policy reform team, which works with administrators, general counsels, board of trustees to revise their policies and make their schools better places for free speech. However, when schools do violate the rights of their students, when they slip up, whether maliciously or by accident, we're there to defend the students. We write letters to schools. We advocate on behalf of students and professors. We'll use the court of public opinion, blogs, press releases in order to put pressure on the schools to do the right thing. All FIRE wants to do is help schools live up to their promises to protect free speech, and in some cases, their First Amendment obligations as public institutions bound by the First Amendment.
Now, in the past week or so, and when you were supposed to be on last week, we had some technical issues. So again, thank you for rejoining us. I had pulled together a number of cases that you worked on recently, but just as you were about to appear last week, an announcement was made regarding something called Title IX regulations. And they facing essentially a significant revision, adopting new protections. Explain to us, because this is the umbrella under which a lot of your work is often reflected, if I could be so bold in saying that. And please correct me when I'm wrong. Okay, great. Explain to what folks Title IX regulations are, and why they are such an important part of your daily life, and why it's so critical that for the first time, really, after a lot of effort, is it fair to say that FIRE, in conjunction with student groups, are starting to shape that narrative?
It's true, absolutely. To provide some background, Title IX is a federal law requiring all educational institutions in America that receive federal funds to not discriminate based on sex. Under the regulations for this law promulgated by the Department of Education, specifically the Office of Civil Rights, this requires schools to address, prevent, and investigate instances of sexual misconduct, including sexual harassment, sexual assault, and other felony-level offenses. In the past, before these regulations came out, many schools were not doing a great job of doing this. For example, they were expelling students, branding them as sexual offenders, and ruining their educational careers without giving them a chance to defend themselves, to tell their side of the story, to have just the basic fundamental due process rights. And likewise, they were sweeping allegations of sexual misconduct under the rug, and they weren't listening to alleged victims, to witnesses, to students themselves when they're adjudicating these offenses, which, at one hand, you can't blame schools for. This is a big responsibility. It's a big mandate imposed upon them by the government. At the same time, though, if universities are going to do this, if they're going to have to adjudicate these offenses and determine who's right and wrong and really hold the educational careers of students in their hands, FIRE's position is that they should do this in a manner that's fundamentally fair to all parties, which they can do this by having a set of clear, organized procedures that are fair to victims, to accused students, to witnesses, to all parties involved, which is exactly what these new regulations to Title IX accomplishes.
Talk to me for a moment about the impact of a charge, regardless of guilt or innocence, on someone in academia. The issues that we often talk about, whether it be anywhere from sexual harassment to misappropriation to academic crimes. How chilling is just the very existence of a charge, often not even documented. But again, referring back to that earlier comment I made about how closely major academic institutions collude, communicate, stay in touch. How chilling is that? How important is it to have due process?
when a student levels a charge of sexual misconduct, it's a very serious allegation. An allegation that universities have to take seriously. They have to investigate the charge. They have to figure out what happened there under Title IX, and they should. They have an obligation to make sure that their campuses are safe places for students to learn. On the other hand, universities have obligations to do right by their students by providing them with a fair set of procedures when they get accused of misconduct. And what FIRE advocates for is a balanced approach here, right? When somebody is accused of anything on a college campus, we advocate that the college should afford these students the presumption of innocence, right? The basic due process, fundamental fairness principle that you are presumed innocent to proving guilty. And based on our research, our due process report, we found out that most schools actually don't even provide this principle to their students, that they're not presumed innocent to proven guilty. That's a simple accusation of misconduct, whether it's sexual misconduct under Title IX or other forms of misconduct, can by itself ruin a student's educational career, brand them as a sex offender, and really harm their ability to become a productive member of society. And all FIRE is advocating for is that when these accusations are leveled, the university give the student a chance to defend themselves, like have an opportunity to be heard and to listen to witnesses, to the alleged, to the accusers, to the victims, to everyone involved, to come at the truth of the matter. And I think that's the real foundation of what fair procedures do. They're a mechanism for listening to the truth. And in many situations where it's he said, she said, where there's little evidence involved, it's vitally important that universities use every means available to figure out what happened there before they either dismiss the accusation or uphold the accusation and expel a student or suspend a student from their campus.
Now, the federal government had been directly involved in creating this atmosphere where a relatively low standard for findings of guilt had to be presented to engage the student in any type of discipline. You refer in the documentation and in the press release and the supplied information about this as something called a Dear Colleague letter. That in 2011, the federal government had actually provided. And tell me if I'm out of bounds here, but from a legal perspective, this is almost identical to, say, a judicial sentencing guidelines. Is that a fair statement?
The Dear Colleague letter was interesting because the federal government characterized this as a binding mandate on the universities. However, it didn't go through the rulemaking procedures required to codify this as binding law. So schools were kind of caught between a rock and a hard place here. Should they implement the regulation? Should they wait until a more definitive ruling? And this prompted lawsuits. It prompted a lot of confusion among schools, many of which resorted to the default position, which is implement the procedures, which unfortunately were not very good for fairness or due process.
Because at the same time, ultimately, if you're the recipient of federal funds, and really just about every state university, every research university, just about every university, every college is the recipient of, at some level of federal funds. That's how what an invasive plant, if you will, the Department of Education has been. You are bound by this Dear Colleague letter, correct?
As an institution that receives federal funds, you'd be bound by Title IX and by the regulations promulgated under it by the Department of Education. Yes.
Right. So this hung literally like Damocles' sword over every proceeding. Yet at the same time, here's a shocker, the actual outlines were vague and unsupported. So what's happened now? What's the current state of the art in terms of Title IX? Does FIRE feel comfortable that, in fact, for the first time, there's a clear articulation of what the intent is by the federal government in determining what legal standards must be available in the case of a campus-led legal proceeding? Is that too grand a pronunciation?
FIRE is pleased to see the Department of Education promote these clear rules about campus procedures and due process. We have a set of rules that gone through the rulemaking process that have been under review for over a year, that have been commented on by thousands of commenters, and that have the Department of Education's reviewed, and promulgated this final set of rules that colleges will have to adopt in mid-August. And I think this is really important because for the first time, it provides colleges a roadmap for how they should conduct their Title IX disciplinary proceedings. And the regulations contain many of the aspects that FIRE has long advocated for. For example, if a student is facing criminal charges, if they are facing expulsion from school, they finally have the ability to bring in an advisor, even a legal counsel with them to help them undergo these proceedings. They have the presumption of innocence. They have, for the first time, access to all the evidence. Under previous procedures, the university had no obligation to provide the students with all the evidence they gathered, including potentially exculpatory evidence that could help the students. Under these new procedures, the university must now disclose the evidence to the students. Another important factor is that during these proceedings, the accused student has the right to cross-examine through an advisor those that are testifying against them. And the cross-examination has been determined by the Supreme Court of the United States of America to be the greatest engine of eliciting truth in our society. It really helps the university, helps students, helps witnesses understand what really happened there by questioning those who are testifying for the school. And it helps both parties. It helps the alleged victims, it helps the accused student figure out the truth of the matter here. And I think there's one thing that all parties can agree to is that the university should be in the process of figuring out what actually happened here. Whatever finding they actually hand down should be based on all the available evidence and the actual truth, which though universities may not have the resources or the institutional knowledge as police departments and judges and prosecutors, we think these procedures give them the best available means to figuring out that truth and making the most accurate outcome.
Excellent. I mean, ultimately, so many schools have been placed in the situation of this amorphous environment where they were placed, it was almost a can't-win situation for so many of these schools, not understanding fully their legal responsibilities, not understanding fully the students' rights. It's a recipe for disaster, and in so many cases where college police have either appropriately turned over or inappropriately retained the proceedings for these, now at least there's a roadmap, and that, I think, will promote not only just fairness, but unfair or unwarranted litigation, hopefully. That is the result. Are many of these cases, as a rule, and I realize there are no rules per se, but are many of these cases in terms of the proceedings at the campus level, when there's an allegation of sexual assault, A, do they occur at the campus level, and B, what information is available in the term of, for lack of a better term, court records, cross-examination, for example, the results of that? What is that available to the university community or the general public at large?
Yeah, that's a good question. One of the biggest indictments of the previous system was the hundreds of lawsuits filed by accused students and alleged victims against these rules, against universities. And many of these lawsuits contain allegations that are really quite troubling. For example, you have victims being forced to testify 5, 6, 7 times because the university keeps screwing up the proceeding. They kept going through appeal and re-traumatizing them. You have accused students being expelled from school without a chance to defend themselves, without any sort of ability to present their side of the story or call witnesses. You have cases where universities deliberately ignore relevant evidence and kind of come to their own conclusion based on whatever they want, the kind of a preordained result. And this is really the opposite of a fundamentally fair proceeding. You don't have an impartial tribunal. You don't have presumption of innocence. You don't have access to evidence. And what many of these cases demonstrate that the university's proceedings previously were not working. That weren't working for victims, for accused students, for really anybody. And what these lawsuits demonstrate is that wide-scale reform is needed for these procedures, and that's exactly what Title IX regulations do. They have universities come up with a set of procedures that helps them go through these proceedings, have a documented, clear, organized structure that they can use to process these proceedings and actually have a fundamentally fair result. Mm-hmm. A lot of the information that may be revealed, a lot of information that occurred could be information that would be protected under FERPA, may not be disclosed by the university. But from our understanding, FIRE's belief is that the previous regime wasn't working for anybody. And we hope that with these new rules, all parties involved will be better off.
Well, and that's the ultimate hope, is that folks who have been legitimately accosted at any one of a number of levels will, because of the strength of the system, seek redress perhaps more often and more appropriately because they have confidence in the system. It's not this helter-skelter amalgamation of pre-made laws that, and at the risk of trying to be humorous in a difficult situation, seem not unlike the apocryphal judicial proceeding towards the end of the movie Animal House. For folks who are victims, I have two daughters who went to college. One of them was a classmate, if you will, of the young woman at Columbia University who felt compelled as an act of protest to carry her mattress for 2 years, upon which she was accosted. And so if ultimately folks who have been victims of crime have more confidence in the system, I believe they're much more likely to seek redress. At the same token, if in fact there's an opportunity for cross-examination and a fair trial, those folks who are guilty will in turn bear the real effects of being guilty and can't hide behind a chaotic legal system. So it's a profound change in the very way that campuses operate, because campuses for too long, it's my opinion, and I love your opinion, obviously, you are the subject matter expert, but for too long, campuses have tried to hide criminal proceedings because of their impact potentially on admissions or public relations, while simultaneously different sides have gamed the system. I'd like to think that the folks who were criminal in nature perhaps were more likely to game the system. But again, the result was just this mess that ultimately served no one. Is that a fair statement?
Yeah. Yeah, that's absolutely a good point about having confidence in the system. We want students who are victims of sexual misconduct to come forward, to have confidence that their accusations will be heard and processed and prosecuted in a robust and fair manner by the university. It's an absolute responsibility of the university to make that happen. At the same time, we want students who commit these heinous acts to be found responsible. We don't want them to be able to hide behind layers and layers of arcane bureaucratic procedures that don't allow any sort of meaningful hearing process. These procedures promulgated by the Department of Education, Office of Civil Rights, they give universities a roadmap for having it the best of both ways, right? They require universities to listen to accused students, to hear their case, to have a hearing process that allows them to present witnesses and relevant evidence. They allow accused students to present their side of the story, to exculpate themselves, and to have a proceeding that they can believe is fair. And this should reduce litigation regarding this issue. They should allow more alleged victims to come forward, and it should give students who are wrongfully accused of these crimes a chance to defend themselves. We think it's best for all parties involved that universities adopt these procedures and work with FIRE if they would like to this end, to ensure that their procedures are fundamentally fair and they're best for all parties involved.
No, and that's why my heartfelt congratulations to you. Again, as the father of two daughters who are recent university graduates, both schools set in urban settings, both schools having tumultuous cities that they're surrounded by, knowing that, in fact, they've professionalized at a variety of levels, and that, because ultimately there will be counter effects or after effects of this. You've got to be, your university police department has to be on their A game if in fact they're going to be called for or to provide information in a formalized legal environment. The school's attorneys have to make sure that in fact university code of conducts are up to a modern status. The residual effect of this, the intended side effects of this are profound. And ultimately, I believe, particularly in the chaos that's coming in our school systems and our university systems, are going to be critical components of really adjusting students' vision to the real world. And so again, my heartfelt congratulations on this. This is the culmination, I can tell, of literally years of work, years of effort, not only just in the promulgation of the regulations, but by routinely reinforcing the notion at the university level that they have to comply with at least the basic legal standards that exist in heretofore mentioned real world. So that's just astonishingly good work. So again, congratulations to your entire team.
Appreciate that.
We've only, excuse me, bear with me on my voice. Anyone in the libertarian movement knows that we've all been talking literally, seemingly for weeks, nonstop. We've got a couple of quick cases. We're a little bit of a short leash tonight. And again, if you're just joining me, Zack Greenberg, he is of the Foundation for Individual Rights in Education, FIRE, has rejoined the coalition tonight, hopefully in a recurring, or at least semi-recurring set of appearances to update us as to what's going on in the university community. Folks, if you're just listening to the first time, we're based in Providence, Rhode Island, very often sort of ground zero for university drama, being the home to schools like Brown University, the Rhode Island School of Design, Providence College, and about a half a dozen other schools, including Johnson & Wales University, the largest and perhaps most prominent culinary institute on the planet. Some of the cases that come up, you almost have to stifle a smile because you just have to wonder what people are thinking. But at the same time, these dramas are real and exigent in these students' life. You had a situation now where, as a result of if you will, a school being operated by the federal government, you had a Kansas student who was forced to sleep in the car after a university kicks him out of housing during a stay-at-home order. How does this, again, I have to wonder, these are adults allegedly in charge of institutions. How did, and the students, although they are young adults, are young and will often say things that they either mean or don't mean but don't understand. Tell us about this. This is nuts.
This is Haskell Indian Nations University in Kansas, Lawrence, Kansas. And what happened was the student, Russell Parker, was golfing on his nearly empty campus when he was approached by an administrator who essentially told him, you can't golf here. The administrator asked him if he was a student. He said he was a student. He got into a bit of a verbal argument with the administrator, and who threatened to tow his car. And Mr. Parker called the administrator an asshole. The administrator claimed that he was being threatened by Mr. Parker when he was putting away his golf clubs. He said he was threatening him with the golf clubs by putting him in his car per his order, and issued an emergency suspension of Parker, requiring him to vacate his dorm during the coronavirus, during the pandemic, during the governor's stay-at-home order, requiring individuals to stay home. And as most college students, this is where he lived. His primary residence was his dorm, and that rendered him homeless during this pandemic. And just ignoring the fact that this, for in all likelihood, was not a true threat. This was protected speech. This was Parker expressing his frustration at the administration. Ignoring that fact, the university refused to grant Parker a hearing on his emergency suspension, despite policies, including the university's own policies, requiring them to do so. The whole point of an emergency suspension is to remove a student from campus who is posing a direct threat, allegedly, and to give him that hearing, an opportunity to be heard as soon as possible, because the sanctions here, the restrictions are so severe, especially in this case.
Yeah.
And we wrote to the university, we published a press release urging the university to do right by its students by granting Mr. Parker a hearing. And that's kind of one of the big thing in this case is about due process. It's about giving a student the right to defend themselves before they suffer any kind of loss, such as housing. And the fact that the punishment was imposed beforehand, and the university refused to grant him that hearing for weeks, is, in our opinion, an egregious violation of students' rights.
Because ultimately he had to live out of his car.
He had nowhere else to go. I mean,
right.
If you kicked most college students out of their house, out of their campus dorms, many cases they don't have another house to go to, or if they do, it's not in the same state or even the same country. It's evicting somebody based on what we believe is a few choice words to an administrator.
Right. That really required more of an apology than literally a potential life sentence. What's astonishing about this is this happens in an environment where the government is so eager to crack down on individual rights, claiming an emergency, and that's an entirely different subject for debate, right? I believe in the seriousness of the COVID, I'll call it illness, the tragedy, the plague. But at the same time, I still reserve the right to point out grotesque government overreaction. So the government then effectively creates an edict where you are confined to your residence and then eliminates the residents. And take into account that across the country, here in Rhode Island, here in Providence, you've got international students, students from sovereign Indian nations, students from the Pacific territories, students from the Caribbean, students from around the planet who are all of a sudden finding themselves potentially homeless despite making significant investments in tuition and room and housing at said same universities. You know, it seems humorous, but it's ludicrous and it's dangerous.
It is 100%.
It strikes me, and I'll allude back to my opening statement, an entire generation of faculty administrators, and I try to keep this light and lively a little bit, but who clearly went to the Dean Wormer School of Academic Relations. And while knowledge is still good, what has to happen to make petty bureaucrats understand that while they have the ability to potentially at some level levy these type of punishments, that doesn't mean they should. There's something I'm missing here.
I mean, the university has a lot of tools at its disposal for protecting the safety of its educational community. Emergency suspensions are one of these tools. It's a very drastic tool. It's a tool imposed without due process, without a hearing, for immediate threats to the campus. We're talking like active shooter situation, student is going to commit harm to somebody immediately. Because it's considered to be a violation of due process when you punish a student before giving them that hearing, right? The hearing comes first and the punishment is kind of a basic principle of our legal system. And we feel that in this case, the tool used was not proper. It was not the correct response to a situation where even in the universities, taking their account as true, is a situation that does not impose any sort of direct threat whatsoever to the administration. I mean, the student was holding a golf club and called an administrator an asshole. That's what the university claims happened. Parker has a different story, which we hope he will be able to present at his hearing, which makes the fact that he didn't get a hearing for weeks even more egregious here. And I just want to point out that in Philadelphia, the greatest city in the world, which it is, to give you an example, the coronavirus effects, they had a ban on evictions, that landlords could not evict tenants during this time, did not pay their rent. And it's a very common edict that's occurring in many cities in America. And I'm looking at this, this law in Philadelphia, and I'm reading this case about Russell Parker and Candace, and it's just really a disproportionate reaction that Haskell imposed upon Parker to cancel student housing during this pandemic, during a state of emergency, considering the circumstances.
Well, that's why you guys are here. We're blessed at the Coalition Radio Network that we work with a number of organizations, but there are a half a dozen or so that literally I think we have to come out with stencils, because when something like this happens, you have to look up to the sky and you'll see the light go up, and it's sort of, we need to take the fire logo and create sort of like a Batman cutout. We put the fire logo up, and you'll know that somewhere, and you guys will just know where. It's just one of these things. We don't even have to tell you. Somewhere out there in academia, some out of control bureaucrat, some in Soviet Russia, in Soviet workers' paradise, we would have called them an apparatchik, is out there and just hell bent on wreaking vengeance in their own way for some reason. Sad to say, I don't think, even with these new Title IX regulations, that you guys are going to be out of work anytime soon. I'm just going to throw that out there.
we hope that one day before it comes out of business, that's kind of the goal, is to do so much good work and to fix all the speech codes and to vindicate all the students' rights that FIRE has. The world has had no need for FIRE, that we can, all go on our separate lives. But unfortunately, the issue has not abated in the last 20 years of our existence. So we are going to be busier than ever.
Zack Greenberg, where can folks find out more about FIRE, particularly if they find themselves in the unwelcome position of staring double secret or triple secret probation right in the eye?
Yes, we encourage anyone interested in students' rights, free speech, college campuses to contact us at our website at thefire.org. And if you are a student or a professor, or you know of any students or professors that believe their rights have been violated by their college or university, please reach out to us at thefire.org. Please submit a case. It'll go through IRDP. We will get back to you, and we will be happy to discuss these issues with anybody that would like to reach out with us. Our doors are always open.
And that is why you are one of a handful. You and the ACLU and people at Goldwater are our heroes of civil rights. Astonishingly good work. And again, congratulations to your efforts. Let's make this a regular thing. I know we were out of touch for a little bit as we kind of rejiggered our show, but I think we're off to a successful launch. And the occasional technical problem aside, I look forward to doing whatever we can to amplify the amazing work that FIRE is doing. So let's stay in touch. All right, buddy?
Thank you, Pat. It's always a pleasure coming on the show. Thank you for your kind words, and we'll be seeing you soon. Thanks again.
Absolutely. Zack Greenberg, we are the Coalition, loud and proud, outrage porn-free, civilly disobedient media, broadcasting live on the worldwide Coalition Radio Network at coalitionradionetwork.com, facebook.com/the Coalition Radio, on the mighty Twitter at coalition_radio, and of course, coalitionradio.us or coalitionradionetwork.com. Join us there. Listen, if you could take a moment, first of all, your homework this week is to go up to FIRE's website. Again, this is one of those dozen or so websites that we talk about all the time where you can actually engage in first-level research, come to an understanding of a situation from subject matter experts who very often are intimately involved in the ongoing proceedings. So you can find out the truth. You don't have to settle anymore for second or third hand or what we call press release reporting, where somebody's reporting off of someone else's report, which came from a press release from somebody in a press office somewhere at a university who's got their own perspective. No. We don't have to do that anymore. We don't have to yell fake news anymore. Organizations like FIRE and Goldwater and the ACLU and about a half a dozen organizations put together quality websites where, again, you're working with subject matter experts. And that, I believe, will change your perspective on literally everything. We're going to take a break now. We will be back a little later in the evening. Thanks for watching. This will be on rotation at facebook.com/the Coalition Radio. You'll have an opportunity to rewatch this. And also, it'll be up on our YouTube page momentarily. Stay tuned and have a wonderful evening. Thank you.